case is State versus John Smith. Looks like we'll have Attorney Corrigan here for the whole morning. All right. As you both know, but I'll repeat it for the record and to remind you as well, you each have 15 minutes. And Mr. Bendick, you can reserve up to 5 minutes if you so choose for rebuttal. We are going to be videotaping. It will be released on YouTube channel. And so you need to keep your voice up and stay behind the podium. And please do not use the names of victims or victims. Thank you very much. You may proceed.
I would reserve 5 minutes.
Thank you.
And good morning, Your Honor, and may it please the court. I am Alan Bendick. I'm here on behalf of the defendant appellant, John Harrison Smith. Mr. Smith, in February of 2018, turned himself in regarding allegations of murder. At that time, he was 16 years old. He proceeded to spend approximately the entirety of the next year in detention pending outcome of this matter. On February 4th, 2019, he entered a plea of no contest and to the charge of murder, reserving specifically his right to challenge the speedy trial issue in this matter. I think the facts aren't largely in dispute in this case. Mr. Smith was detained as a juvenile. It took several months for him to be bound over to the adult court. That occurred on June 22nd of 2018. According to Ohio law, we don't dispute that at the time. When he was under the control of the juvenile court, that would not count toward his speedy trial issue. The other issues that are not in any real dispute are that his time, he remained incarcerated in detention after that date, and that those times counted a 3-to-1 ratio, so we're dealing with a 90-day window to bring.
So time starts on June 23rd in this case.
June 23rd? I had a date as June 22nd, but I don't think that one date will make a significant difference. The defendant concedes that the trial counsel asked for 2 continuances, a total of 28 days that will be charged to the defendant. Those are the only times that I see as chargeable. The trial date was set at an October 2nd pre-trial to December 10th. There was no speedy trial waiver executed by Mr. Smith. The co-defendant, in this case, Mr. Morgan, did execute a waiver, and you will come across that in some of your readings of the transcript. I think that led to some of the discrepancies in this case and some of the issues. And I think that there are a number of peculiarities procedurally that led to what I believe is a matter that has fallen through the cracks to Mr. Smith's detriment and to the violation of his constitutional rights here.
Can I stop you just real quick here? I'm assuming he filed a motion for discovery?
He did file a motion to discovery, and that is a point that the prosecution brings up, that the prosecution asks for 30 days assessed to the defendant. Regarding that, I would tell you that in the prosecution's response to summary judgment, they did not raise that issue, or to dismissal, they did not raise that issue at the trial.
Would you agree it tolls time of the motion?
I would, but I would also point out that even conceding the 30 days, the speedy trial date for Mr. Smith would have been November 17th of 2018. That I had calculated, as I think I indicated, that October 18th was his speedy trial date, even adding in 30 days for the discovery. As prosecution has argued, the trial date of December 10th was still outside that date. It's undisputable that Mr. Smith did not execute a waiver. So that the trial date of December 10th itself, while agreed to by his counsel, would not be an issue of waiver. It would fall under subsection H of the tolling statute 294572, which is reasonable continuances for motions not filed by the defendant. So even at December 10th, that we are outside of the window for On 10 days prior to that, at the end of November, the prosecution moved for a continuation of that trial. On an assertion that their primary witness, the lead detective, was unavailable, but he had scheduled training at that time. And Dave Lowry, the trial counsel, objected to that continuance as outside the speedy trial window. As indicated, Mr. Morgan had already executed a waiver, so his trial counsel did not raise those issues. I think when you read the transcript, I think you'll see reference. The transcript will read prudent issues. I believe that Mr. Whitney was raising, Morgan's trial counsel was raising prudent issues. I believe that that's an error in the transcript that you'll come across. There was no prudent issue motion for separation filed at any point in this process, or prior or after the continuance of the case. So
the court denied,
they denied,
overruled the objection.
overruled the objection.
Set a new trial date. Did the defense counsel agree to the new trial date?
The defense counsel noted specifically his objection on the record, and that he was opposed to the continuation of that trial at the December 10th pre-trial. He objected to that continuance. He did not agree. That was over his objection that date was set. And that date was set on February 4th, another 56 days beyond the December 10th trial date. And this is what I would point out, is that there is no question that from October 2nd forward, Mr. Smith and his counsel did nothing to extend the time in this case. And it is an act of two separate motions that, I don't have a good legal term, colloquially, they slow rolled this out another 100 days. I think that this court would recognize that a trial date set without waiver some 4 months or 90 days beyond the trial date without agreement from the parties would be deemed unreasonable. I think that's facially hard for the state to sustain. October 10th, they had said, you're going to be out of date, not in mid-November, but we're going to set your date in February. I think that's a clear error. And it's the mere fact of this second motion, which is based on unavailability of the detective. The question that trial counsel raises, and that I think should be raised here, is when that trial date was set on October 2nd, why was there no communication? Why was the detective unaware of that date? Why was the prosecutor not aware of that date, that date would be impossible for his witness at either October 2nd or any point within a reasonable amount of time before a week prior to trial? I think that the case law states that unavailability with a witness is a reasonable basis for continuance as long as there's no dilatory action by the state. And in this case, I see no evidence that the actions taken here were not dilatory, that the prosecutor and their detective could have and should have communicated if that date was not going to work well prior to a week to 10 days before they were set for a murder trial. And again, the trial counsel raises the questions of what is the nature of the training that is purported to be coming in. Is it mandatory? Was it something that could have been continued on his part? This is not an issue where the detective was suddenly unavailable, where there had been a medical emergency, where there was some circumstance that took him out of the court and made it unreasonable for him to be there, or impossible. This was a decision by a state actor as to what, I don't want to sound cavalier because these are significant charges, as to what was important, that there was this training, and there's no evidence of whether this could or could not have been rescheduled. There is a murder trial that was already beyond the speedy trial date, and there was an objection to the continuance from Mr. Smith's counsel. I think that those things are clear, and this is an erosion of a significant constitutional right, And I know that the charges are significant here, and I am not trying to shy away from that. But at this point, and because of the significance of those charges, I think is paramount to the state to focus on those issues and to make sure that they know when those deadlines are. The case law is clear. It is not Mr. Smith and his attorney's duty to know when those deadlines are, to know when that speedy trial date is. That is unquestionably by case law and black letter law that is the state's burden to know what those speedy trial deadlines are. And in no way am I saying that the trial counsel was trying to hide that ball or was trying to create error here. But I think his own statements were that he was comfortable with the December 10th trial date. I have no qualms about that. I think that by any calculation, that would have been considered a reasonable trial date within 29, 45, 72 H. But
You're in your rebuttal time.
then I will save that.
Okay,
Thank you very much.
Good morning, and may it please the court. I'm Jimmy Quinette-Corrigan on behalf of the state of Ohio, urging this court to affirm. I'm going to keep my remarks brief because this is essentially a factual issue that we have, both parties have briefed in a good deal of particularity. I would draw your honor's attention because basically this is coming down to what happened on two dates, October 2nd and December 10th. And what happened in reference to the state's November 30th, 2018 motion to continue regarding the detectives' mandatory training. What's in the record is it's mandatory training followed by a vacation. The case law says that a vacation, as long as it's reasonable, that's a reasonable reason for continuance. There's nothing in the record other than speculation as to whether this was training that this officer could have avoided. However, I would like this court to pay attention to what's in the record at the October 2nd, 2018 pretrial. The state had originally proposed a December 3rd, well actually the court had proposed a December 3rd trial date. The state had agreed to it, however, it's Mr. Smith's counsel who notified the court that he could not try the case on December 3rd, but he had to because he had a scheduling conflict from Medina County. So it was Mr. Smith's counsel who proposed December 10th, and that was the date that was agreed upon. Then, more than 10 days prior to the trial date, the state filed a motion to continue based on the detective's mandatory training. As far as that being a decision by a state actor, there's nothing in the record to indicate that the detective had anything to do with deciding whether he was going to go to mandatory training.
Was there anything in the record, though, that indicated that mandatory training, he was aware of it, and the state was aware of it prior to agreeing to the December 10th date?
No, I don't believe there was, at least not in the transcripts of the hearing on December 10th. No, there was protest by counsel. However, the court did find that the continuance was reasonable prior to notifying the parties that February 4th was going to be the trial date, and then Mr. Smith's counsel acquiesced in that. I thought I heard a question.
Well, is acquiescence in a trial date the same thing as a waiver? I don't think it is.
Well, the case law says that when a counsel acquiesces to a trial date and does so within the time, then that operates as tolling under 2945-72H, because that would be a continuance, any reasonable continuance granted other than upon the defendant's own motion.
But what if he's out of time at that point?
Well, our argument is that on October 2nd, 2018, when defendant's counsel indicated that it had acquiesced to the December 10th trial date, that extended the speedy trial time at that point, that the clock stopped for speedy trial purposes.
But it stopped to the December 10th period. I think
Correct.
that's what Judge Tito's question is going to. How does that mean it somehow made it all timely so that you can just continue on?
And with the, I'm looking at your brief, and it does say that on October 2nd, pretrial took place within the deadline. At that time, the parties discussed more than one date, and Smith's counsel agreed that he was available for a December 20th trial.
Oh, I'm sorry, that would have been a typo. The
It would
December
have been the
20th.
10th.
It would have been the 10th.
Okay, all right.
Yes, sorry, I apologize for that.
And we didn't need a tag team, but go ahead now.
That's all right. No, I mean, on December 10th, the time was still told. And so until the end of that day, the argument would be that if the continuance had been taken on December 11th, that would have been out of time.
So since the state filed 10 days before that date, you're saying, for the continuance, then that was still time?
Correct, and the court granted orally the state's motion on December 10th, which was the last day of time. Because even thinking about it, if the trial had actually commenced on December 10th, that trial would have been considered to have been timely begun. Okay, even though the proceedings would have, obviously continued on, for however long it took to try the case. But any time during December 10th, if that trial began at 1 o'clock in the afternoon, it still would have been considered to be within the speedy trial time because of the actions that had occurred, the acquiescence in that date prior to that.
So you're saying what the state could have done was start the trial on December 10th and then move for a continuance on the basis of the detective not being available?
Yes, because trial would have already commenced. So what
But
I'm
that's not
saying
what
is
the
that,
state did.
pardon?
But that's not what the state did.
No, the state moved prior to the trial during the time period that had been acquiesced to. So the state's argument is that under 2945-72H, both of those continuances were valid and were reasonable and therefore did not violate Mr. Smith's constitutional rights.
So the other side, the appellant has already said that they don't have a problem with the December 10th date. It's that last continuance.
Correct.
So this whole case is going to boil down to whether that last continuance was reasonable.
Essentially, although I thought that there was some contention also as to October 2nd, but that I could be mistaken on that.
Thank you.
Thank you. If there are no further questions from the court, then the state would rest on its briefs and respectfully ask the court to affirm.
Thank you.
Thank you.
As you can see from the monitor, you have 4 minutes and 44 seconds.
Thank you.
Thank you.
The appellee's counsel is correct. There is nothing in the record regarding the mandatory nature or the necessity or the ability to reschedule or inability to reschedule the training of the lead detective in this case. And
Is there anything in the judgment entry?
there is not, and I do not believe so. What I would tell you is that the case law is clear, that once it is established that the trial date is beyond the calculable speedy trial date, once that has been demonstrated by the defendant, it is the state's burden to demonstrate that legitimate tolling action that would continue that date out. And if there is nothing in the record, that is their burden that they have not met, not an obligation on my client to be able to show that it is unreasonable. It is their obligation to show that the continuance is reasonable, and I would contend that the absence of evidence in the record is a failure to meet that burden.
Okay, counsel, then, do you agree that this case boils down to that last continuance,
And I would absolutely agree that I
whether it's
would,
reasonable or not.
I would indicate that I believe that, but that I believe based on the fact that when that trial date was set, October 2nd, Mr. Smith was clearly within the calculable time. That I don't think that's in dispute. I think that any calculation, his trial date was either October 18th or November 17th regarding the best calculations for either side. So when they set that date, that was set within time. I think that it would be a futile argument for me to argue that the setting of the December 10th date and the agreement of council would not be reasonable under subsection H. But I would contend that the raising of the second issue, some month and a half after that trial date, without evidence of why or how that continuance was granted, Your Honor, you look like you're about to.
Well, I'm actually looking at the motion that was filed, and this is in the record, on November 30th, that says that he is scheduled to be out of state during the trial for required training.
And it does say required. There is no evidence in the record as to what that training is or whether that required. There is no evidence that that required training was required to happen on those dates, could not be rescheduled, or when that was set or how it came about to be set on those dates.
So your argument should have been more explicit as
I
to
think
what-
that there should have been evidence as to why that occurred. And that, yes, I believe that statement of, oh, I've got required training in this circumstance, and I know that often that is enough for a continuance, especially, but in civil case, in a case that's not out of time, but in a murder trial where there are speedy trial issues, I think that it was the burden of the state, and it was necessary that they demonstrate the requirement of that, especially over the objection of trial counsel. And and the characterization of his acquiescence in this, I believe, is inaccurate. It is clear that this trial date was set, the February 4th trial date was set over his objection, and that he subsequently filed a motion to dismiss for violation of speedy trial. I think it's just very difficult to reasonably characterize that as acquiescence in that trial date. I am about done. I would ask that this court overrule the